Hello friends, welcome to my channel Between the Lines. My name is Farooq Rathar. I have a modest proposal to make about our judicial process, which I think is in need of a small improvement to prune away its undesirable branches. Only a man from another world may question the urgent need to reform our judicial system that has, with its delays, deeply disappointed all of us. As the system does not disallow deferments, the judges cannot help following it. They don't have anything to gain from the delays. As for the lawyers, they represent equal and opposite forces which cancel each other. While some lawyers may, for varied reasons, be interested in overstretching their cases, there will be as many others opposing and undoing the same. The real spoiler, which is beyond their control, is the judicial procedure which rules the roost. The bench, the bar, the public, all of them watch it do quite brazenly what it does. This is not something figurative or rhetorical. It is so real and severe. The flaws in this process have simply broken our backs. Have a look at the number of pending cases in the country. The table is on your screens. This data is of August 2023 and is provided by the National Judicial Data Grid, an online platform created under the e-courts project to maintain database of orders, judgments and case details of 18,735 district and subordinate courts and high courts. This data is in public domain. Most of you must have already read or heard these figures. I too am not taking these figures for a show or repetition. I have an altogether different point yet to make from these figures. But before doing that, let me rehearse the main figures. The total number of cases pending in is 4 crores 45 lakhs 77,204. This includes 1 crore 10 lakh 60,778 and 3 crore 35 lakhs 16,426 criminal matters. Almost a lakh of these cases are more than 30 years old. And this number does not include more than 96,000 matters that are pending before the Honorable Supreme Court. Now take a closer look at the table on your screens. You see that the number of criminal cases is more than triple the number of civil cases. And this is really what is cruel and appalling. It speaks volumes about the abysmally tragic condition of our society. Criminal cases arise from the crimes committed by a small margin of the population. On the contrary, civil cases take just the peaceful population and their day-to-day dealings to arise for and from. People don't need to be criminals necessarily for having civil disputes between them. In the most populous country of almost 1.5 billion people, where in spite of only part reporting of crimes, the number of pending criminal cases is 2.3 crores. The number of civil cases should have been actually 15 to 20 times more than the number of criminal cases. By comparison with the real figures, the actual number of civil cases pending is therefore 30 to 40 times less actually. And if we discount the civil miscellaneous applications and other secondary motions of procedural nature that are included in the pendency figures, then the number of pending matters carves out an even worse picture. There is far less number of civil disputes present or pending in our courts than what ought to have been. This pathetic state of affairs highlights the people's lack of confidence in the judicial system, which is accordingly evaded as far as possible. People do not choose to approach the civil courts unless and until it is the last and final option available. However, avoidance of the judicial process may wish away the occurrence of civil disputes, but if wishes were horses, all of us would be riders. More and more civil disputes actually keep rising with the growth in population and its activities. So the real situation that prevails all across is that the disputes are confronted even though the courts are averted. Predictably, therefore, people resort for dispute resolution to extrajudicial means, which obviously avail them only in two forms. One is the untold official mechanism of corrupt practices that have since matured properly into the larger than life spectre, which spares literally no one in the land. The other is the unofficial damned group that too has equally flourished over time as a parallel administrative world of the underworld. This increasingly persuades one to infer, without any fear of contradiction, that the invisible avoidance of litigation is more disturbing and gut-wrenching than its visible pendency that is being talked about so much. In other words, aversion is the far bigger judicial crisis than the prolonged pendency of the cases that are only far and few. Nevertheless, I am not making any case of official apathy or inaction. In a bid to reduce the backlog of cases, the governments have been generously adding more courts from time to time. And the legislatures have also been on the forefront to put forth new laws of procedure. But these measures have proved to be deficient for obvious reasons. New courts cannot be added as quickly and as proportionately as do the people and their disputes. And none of the amendments has schooled the guilty system yet. In effect, therefore, even the best possible performance of the available courts and the judges remains elusive, the same way as the defense of martyred soldiers against an overwhelming enemy. More drivers may make more trips, they cannot fly the vehicles. Lok Adalat has now been there for about 35 years as another dispute resolution mechanism in which pre-litigation conciliation and amicable settlements remain the preferred option of the functionaries. But that has its own say about the failure of the judicial process to deliver as expected. Conciliations and settlements are certainly not bad in themselves and are never undesirable. But their facilitation by judicial officers is to an extent contrary to the sacred role of adjudication of the latter. Mediation can be done by anyone. Judges should be there to adjudicate promptly if the mediation did not work. In medical science, they say cesarean delivery is the failure of obstetrician. So it can be safely argued that lots of people may not go for settlement if the ordinary courts do not protract adjudication. Terrible have been the psychological effects of the belated justice that is generally taken to constitute no justice. Most of us have come not to care if needed. The bad guys know they can get away for years after violating somebody's property or personal rights. The good masses, with no reason to look up for justice, prefer to be content with what they get. They may be wrong in blaming the judges for the failure of the judiciary, but they are not wrong in their feeling of being wronged about justice. All the wrong reasons have jointly made justice a rare luxury brand that can be acquired only after running the marathon of judicial procedure. And in the absence of any replica, justice is not to be expected elsewhere in the society. I won't be wrong unless and until the court has corrected me. Having said that, it must be added that the problem is not incurable. The process of criminal trials can be hastened by dedicating more time to them. That will be possible when we spare more time from the civil disputes. And this is precisely what can be done without any unease or inconvenience. Simple and speedy adjudication of civil disputes can become the mainstay of our ordinary courts. No need for any special courts or tribunals. The proposal is based on the fundamental idea that in a civilized society, to be human is to be just and fair in one's dealings. Therefore, the people must be habitually self-correcting, expecting a quick judicial intervention if they deviate and do not mend. That will have the wonderful implication of the people being satisfied with the conduct and dealings of each other. Whenever anybody's particular conduct is questioned by someone, the former shall, in case of disagreement, join the latter in having the just conduct determined by a court for sure observance. The plaintiff has the inherent right to justice and should not be put through the ordeal of extracting or exacting justice through the courts. Both the parties to a dispute, having failed to resolve the same agreeably, must jointly submit to the court their points of difference for judicial adjudication and compliance. This method can apply to all types of civil disputes, whoever the parties. The judges would directly come to the points of dispute and would naturally take lesser time to decide them. They will also come to have more time to give to the criminal trials. The parties and their lawyers would jointly approach the court with almost all the relevant and supporting material. The honorable judges won't have to waste their precious time in literally going after the defendants to acknowledge the court notices. As the people themselves must be fair in all that they do and do not do. The duty of the courts is only to impose justice where it is denied. But people can obey such law only when the legislators make it. We have to have a civil justice system in which the people are compulsorily just and justice is there to confront them easily whenever and wherever they are unjust. The existing procedure consumes most of the judicial resources not in deciding the disputes but in determining the propriety or otherwise of service of notices, production of documents, evidence, and other procedural frivolities. The proposal urges for eliminating these useless processes and scope for raising any secondary issues. Once that happens, the adjudication of the real disputes will be radically simplified and expedited. Anyone raising a dispute with somebody must be seriously and maturely responded to. And if he is not satisfied, the respondent should accompany him to the court with their dispute. There is in fact a provision to this effect already present in the Code of Civil Procedure in the form of Section 90 to be read with Order 36 titled as Special Case. These two provisions prescribe that any persons may agree to state their case for opinion of court. It is more or less a kind of arbitration agreement for arbitration by an ordinary civil court. Ironically, the speciality of these provisions has become their disability and has rendered them virtually untouchable. The prime defect of this order is the dependence of its applicability on an agreement of the parties to submit their case under this order. Obviously, any unfair party has every reason to stay out of this provision and thwart the course of justice. Secondly, the non-appealability of a judgment passed under this order is yet another reason for anyone to evade invocation of this order. There is no reason why these provisions for only special case with appropriate emendations and amendments cannot be made as provisions for all cases. In its generalized applicability, all civil disputes would be extrajudicially raised at the personal or official levels by the parties. If and when the parties fail to resolve them agreeably at their level, then only the points of difference would be jointly submitted for adjudication of the courts. For an example, if a person disputes the title of someone to a particular property, he would put forth his claim personally or through his lawyer. If the defendant disagrees, he too shall, generally through his lawyer, assert his own title. then the two lawyers will frame up their points of difference for the judicial adjudication. Soon the parties together will be before the court with most of the facts admitted, and the court will straight away start hearing on their disputed facts or interpretations and return its findings sooner than later. This way, even the complex matters will be already half done before reaching the courts. The documentary evidence can be produced along with the memorandum of differences, and the oral evidence can also be adduced with mutual cooperation without any delays. Either of the parties dissatisfied with the judgment of the court would have the right to appeal against the same. However, the appeal also would be preferable in the similar manner. The appellant highlighting the grounds of appeal before the opposite party, who in all likelihood may disagree, and then both of them shall appear jointly again before the appellate court, argue and hear the verdict. In that system of judicial civil justice, there shall be rarely ever any need for interim orders and injunctions. These will become redundant matters of very little purpose. It will also eliminate the various procedural stages which are known to distract and distance the courts from substantial justice. All kinds of special courts, along with the lok adalats, will become obsolete and redundant. The lawyers, too, would become real performers in the administration of justice, with almost no scope for exploiting or swindling. The costs of litigation will come down significantly, and justice will be within the affordable reach of one and all. For the purpose of containing the exceptional aberrations of thwarting the process of justice by some oversmart people who are never out of stock, there can be, among other things, an appropriate law of undesirable consequences to change them. Such law will ensure that everybody responds quickly and sensibly to any dispute raised with him or her. The proposed system can be visualized as literally revolutionizing the dispensation of justice, regardless of who the particular judge might be. After all, good or bad performance of a system is primarily determined rather by its deviser than its operator at a given point in time. Aeroplanes have the ability to fly because their makers have made them so. The pilots only utilize that ability. This system of civil justice can also be expected to save the whole lot of time, enabling the courts to allocate the same to the criminal justice by holding almost uninterrupted trials. Last but not the least, a remarkable benefit would be that our big investors and entrepreneurs would be gladly doing away with foreign arbitration clauses in their deals. Thanks for watching.